Kalis binti Muhammad Kamsu. I am presenter number 1.
My name is Siti Nuraisha binti Zawawi and I'm as a second presenter.
My name is Nofar Najwa binti Muhammad Shukri and I'm the third presenter.
What is industrial relationship? According to the Industrial Relationship Act 1967, contracts employers as well as employees several rights and at the same time imposes the several responsibilities on them. Rights is meaning a proper authority or something that a person or a party is entitled to legal and valid acts or acceptance of certain things. Other than that, contracts employers and employees the following rights is the right to form, to assist in the information of, to join a trade union, and to participate in its lawful activities. Next is the rights to establish, to function, or to administer a trade union. Other than that, to be free from any influence or control by an employer or a trade union in employers through financial support or other means. The objective is to promote the promotion and maintenance of positive and harmonious relations between employers and employees and their respective trade union in organization. This objective is to create peaceful and conducive in industrial relations.
Director General Industrial Relations Malaysia is the chairman of the Industrial Relations Department. The Yang di-Pertuan Agong has power to appoint the Director General, who is individuals from the Industrial Relations Officer Program of Service that will be appointed, and such appointments will be announced in the Gazette. Furthermore, the Yang di-Pertuan Agong also has the authority to appoint the Deputy Director General for the Industrial Relations. The Director General of Industrial Relations is in charge of the overall positions, regulations and monitoring of all industrial relation issues facing the country. Since the Director General leads the department, he has assistance in carrying out his responsibilities, which is supported by the Deputy Director General. The Director General should report to the Minister of Human Resources, and he is accountable to the Minister of Human Resources via the Secretary General of Ministry for all the departmental powers and responsibilities. Industrial Relations Act 1967, Industrial Relations Regulation 2009 and Code of Conduct for Industrial Harmony that has enforced by the JPP Malaysia are among the laws and regulations that fall within the Director General duties for the industrial relations.
The first power is to solving the disputes. The power can be seen in the process of recognition, Regulation 3 of IRR 2009. There are 5 main stages in the process of claiming recognition by trade union from an employer. The first stage is the application, which is the basic process that must be made in writing by fill in an application form and will be submitted to the employer and also the DGIR. For stage 2, in 21 days after the receipt of such documents, the employer needs to respond either to accept the recognition or refuse to accord it. In the third stage, if the employer rejected the claim or if there is no reply made after the period given, the trade union can lodge a report to the DGIR. In the fourth stage, the action will be taken by the DGIR. In the stage, the DGIR can take any action which is necessary step to represent the workers. In the last stage, they are authorized to request for the detailed information from the parties involved in the resolving the matter. The next power is competency check. The DGIR must refer to the DGTU for competency check. Competency check in the recognition process was outlined clearly by the court. It is a standard practice in the DGIR's office to conduct a competency check, although it is not mandatory in the regulations. In the case of Minister of Labour and Manpower versus Peterson, Candice and Dan Berhad, namely, the worker must be within any similar trades, occupations, or industry as written in the trade union's constitution. In respect of similarity for a trade occupation or industry, it must be similar according to the opinion of the DGTU. It is a standard practice in the DGIR's office to conduct a competency check, although it is not mandatory in the regulation. The respondents further contended that the competency check could prevent the employer from resorting to objections and judicial reviews that will further delay the recognition process. The objectives of implementation of this provision can be traced back to the introduction of Trade Union Act 1959 in 1940, when the communist movement and ideology were a threat to the colonial government. By dividing the trade unions into different categories, and suspicious activities that may cause harm to the state can be immediately identified by the authorities. The government feared that omnibus unions might be led by persons having nothing to do with the professional activities or interests represented by organizations, political, or even subversive aims. Competency check of the trade union is not against the principle of freedom of association. The last power is the response to each representation and complaint made. The Department of Industrial Relations in Malaysia is established to cultivate and maintain a positive and harmonious relationship between employers and employees and their trade unions to create a safe and peaceful industrial relation in the country. Therefore, this department is responsible for resolving any trade dispute. Trade disputes are disputes between employer and his workers related to the employment, non-employment, and conditions of employment of the workers in Section 2, Industrial Relations Act 1967. One of the powers of DGIR is responding to each representation and complaint made by the employees, employer, and the trade union. This power can be referred to Section 20, Clause 2, which states that upon receipt of the representation, the DGIR shall take such steps as he may consider necessary or expedient so that an expeditious settlement thereof is arrived at Industrial Relations 1967. From the section, it has clearly stated that the GIR shall take a step by responding each representation and complaint made in order to ensure the process of settlement between employee and employer runs smoothly.
The example cases is such according to the article Trade Union Recognition in Malaysia, the legal issue for the case HSBC Bank Malaysia versus Menteri Sumber Manusia. In this case, the DGIR may conduct an investigation into the job responsibilities of the employees in questions to determine whether they are executive or not, in accordance with Section 9, Clause 1A of the IRA. This investigation will eventually determine which union will represent the employees under the considerations.
The next cases in the case of M. Bank Berhad versus Menteri Sumber Manusia and Anna and another April 29, the Association of Bank Officers Peninsular Malaysia, ABOM, submitted a recognition claim to M. Bank Berhad to represent the workers under the position of Executive Scale E. The employer requested the DGIR to carry out a membership check by conducting a secret ballot. The secret ballot result indicated that 210 workers were within the Executive Scale E category. ABOM invited the bank to participate in the collective bargaining with the Executive Scale E workers, but the bank refused the invitation on the grounds the ABOM had expanded the scope of the categories by including workers from Executive Scales E1, E2, and E3 in the bargaining processes. The employer accused the trade union of an attempt to generalize and then sought the benefit of a wider interpretation of the categories. On the other hand, ABAM alleged that the bank's accusation was an attempt to forestall that the trade union's recognition claim as the denial of the scope of representation was an afterthought by the employer. The Court of Appeal allowed the bank's appeal on the grounds of the minister's failure to not make any in-depth analysis or ask the right question in determining the scope of representation. The court decided that ABAM had to make a separate recognition claim to the employer in representing the different categories of executive Scale E workers.
The third case is the United States of America versus Menteri Sumber Manusia Malaysia. The third responded commences employment at the applicant's embassy in Kuala Lumpur as well a guard pursuant to an employment contract, which was supplemented by document titled Condition of Employment, which is guard services only, signed by third respondent. The third respondent failure to report for duty was stated as a ground for dismissal in the conditions of employment. After failing to report for duty for the third time, after being given written warning for the failure, the third respondent was dismissed from his employment. Dissatisfied, the third respondent filed a representation to the Director General of Industrial Relations, claiming his dismissal was without just cause and excuse, and sought reinstatement to his former position. The conciliations meeting between the applicant's embassy and the third respondent was unsuccessful. Subsequently, the minister decided to refer the third respondent representation to the Industrial Court of Judications under Section 20 of the Industrial Relations Act 1967. Hence, the present judicial review application by the applicant challenging the decision of the minister. The core issue here was whether the applicant and its embassy was immune from the jurisdiction of the Industrial Court with regards to the third respondent's reinstatement claim of the principle of sovereign immunity. The conclusion is the context of Malaysian industrial law, the right to industrial act is identified but is severely restricted. While workmen are not denied their right to strike, this right is limited to achieve a balance between unrestricted freedom to strike and the need for industrial peace in the interest of economic development. Trade unions must abide with all the laws, especially the provision of the TUA 1959. It should prevent any members from carry out illegal activities such as strike, administer funds of union on a proper manner and in accordance with the union rules as well as the law is duty of trade unions. Trade unions must serve notice from recognitions on employers or trade union of employers.